Good morning. It's 9 a.m. and I'll call the October 7th meeting of the Board of Supervisors to order. Welcome our guests today. First item is approving the agenda.
I'll move to approve the agenda.
Second. And a motion made by Supervisor Kiefer, seconded by Jorgensen to approve the agenda. As presented. Those in favor say aye.
Aye.
Aye. Motion carries. Second item is public comment. Is there a public comment from anyone? We accept public comments on any item that's not on the agenda. And you can comment at any time, or we'll recognize someone at a time when we discuss the agenda item.
I can go now, or I can continue
We'll on the agenda. Well, welcome to our meeting, and when we get to agenda item 6, which is going to be very shortly, we'll open for a comment from you at that time.
I'm happy to wait till then. Thank you.
Thank you. Is there anyone listening on the phone line that would like to make a public comment at this time? Hearing none, we'll move to item 3. Review action regarding approval of the September 30th, 2024 Board of Supervisor minutes.
Make a motion to approve September 30, 2024 minutes.
I'll second.
We have a motion by Supervisor Jorgensen and a second by Kiefer to approve the minutes of the September 30th Board of Supervisors meeting. Is there any discussion? Comment from anyone listening on the phone? Those in favor of the motion to approve the minutes say aye.
Aye.
Aye. Item 4, review action regarding approval of the claims.
I looked at the claims. I didn't see anything seemed out of ordinary, so I'll make a motion to approve claims.
I will second.
I have a motion by Supervisor, seconded by Jorgensen to approve the claims as presented. Further discussion? Hearing none, those in favor of the motion say aye.
Aye.
Aye. Item 5, updates on various boards, commissions, and activities since the last meeting.
I didn't attend any, but Dennis was gracious enough to cover for EMS.
Yeah, I attended the EMS meeting Jim mentioned. They went over what their proposal is for an informational campaign on the EMS. Also attended the Floyd County or Chickasaw County landfill. They will be needing to build another cell in the next fiscal year, which they estimate the cost to be about 1.4 million. So it'll be kind of a big project. Also attended Chamber of Commerce Hotel Motel Tax Tourism Steering Committee, and they've asked for a donation for new banners along Main Street to advertise and promote Charles City. That's what I think. There's a total of 40 of these banners. And, so that was my boards and commissions.
Thank you. I attended the department head meeting, discussed a variety of topics, including our decision to reinstate a compensation. Someone on our call-in line is making a little noise. If you could please silence whatever it is you're doing, we do appreciate it very much. Thank you. And so we just talked about the requirements, and in fact, we will be appointing 2 members of that, if you recall. Need to do that. What they do is the 18th November. And we can reappoint and appoint. Other than that, I did work with the zoning department again on mapping of the setbacks. Item 6, which is review action regarding the letter received from Samantha Norris, Brownwood Law, attorney representing Marble Ridge Wind Energy LLC, affiliate of Invenergy LLC, concerning proposed wind energy ordinance revisions and potential action to go into closed session for Iowa Code 21.1 para 1, para C, quote, to discuss strategy for its disclosure with counsel in matters that are presently in litigation or litigation, position of the government body in that litigation. And letter A, we're starting off with a discussion with county attorney regarding his opinion on going into closed session. When the board discussed this agenda item during future agenda items at our meeting on Monday, September 30th, Supervisor Jorgensen suggested that the discussion should be held in closed session. And later that day, I asked County Attorney Pritchard for his legal opinion whether or not the Board of Supervisors could legally go into closed session under the Iowa Code 21.5, para C, para 3, that allows a closed session to discuss strategy in matters that are presently in litigation or where litigation is imminent. On Wednesday morning, October 2nd, County Attorney Pritchard responded to my request with the email sent to me and CC to Supervisors Kiefer, Jorgensen, and Auditor Carr. The written copy of the email was included in the board packet, and County Attorney Pritchard is with us to answer any questions you may have. The email states, not too long, I'll read it. Mark, you asked for my opinion on conducting a closed session to consider the letter the board received from attorneys for Mtg. As you are aware, the letter threatened litigation if the county wind ordinance passes in its current form. Iowa Code 21.5 provides for when a government body can legally go into closed session. The relevant section in this instance would be subsection C, that allows a closed session to discuss strategy in matters that are presently in litigation or where litigation is imminent. Given the current situation with the Mtg letter of potential litigation, if the county stays its current course, I do not view the situation as imminent, that there will be litigation. The county has yet to pass the ordinance, and nothing has been filed with the courts by Mtg or other. Given the current situation with the wind ordinance, however, I would characterize the situation as likely that Floyd County would be sued if the ordinance passes in its current form. However, at the present time, we do not see litigation as imminent. Please do not respond. Please do not reply all to this message to avoid any open meetings violation. Todd Pritchard, Floyd County Attorney. I believe it should also be noted that Iowa Code 21.55 states nothing in this section requires a governmental body to hold a closed session to discuss or act upon any matter. Supervisor Jorgensen and Supervisor Kiefer, do you have any questions regarding?
Yeah, based off of, I believe we went into closed session when we hired legal counsel for my time.
Well, we went into closed session because litigation's imminent, and we were gonna initiate litigation. This, this letter, this Morris happens to be here, but this is kind of, I view this as a warning. So this doesn't say imminent. The ordinance isn't in place. So for me, I don't think it's fair to characterize it as imminent. It's just like it's gonna happen. We're not there yet. It could be. At this stage, we haven't had the third reading, we haven't taken a vote. We're still in the consideration stage technically. I wouldn't consider us.
What would be what would be the problem with going into closed session anyway?
We don't have legal grounds to do it. You know, I don't, my legal opinion, we're not imminent, in litigation. We don't have legal grounds under chapter 22 or, because it's quite specific.
Any other questions?
Well, I don't know if I got a question if I'm confused, but this letter from the attorney is more than a threat to me. I mean, it is a threat. If we don't give them what they want, then they're gonna sue us. Right? I mean, that's my interpretation of the letter. But that's no reason to go into closed session and talk about it, correct?
I mean, you know, we call this saber rattling, right? It's basically like, as I read this letter, it's basically saying, you're gonna pass this ordinance, and we're gonna consider suing you, right? There's nothing that's been filed. We haven't passed the ordinance yet. To me, this doesn't rise to what is imminent. There are a lot of things that could or could not happen that may or may not give rise to a lawsuit.
Any other questions? Before considering any motion, whether or not to go into closed session, I believe a brief review of Iowa Code 21.6, which is titled enforcement, is in order. We'll see, you can find it in the code as well. And Iowa Code 21.62, para 2 states, the burden of going forward shall be on the governmental body and its members to demonstrate compliance with requirements of this chapter. Code 21.6, para 3, para A states, upon a finding of preponderance of evidence that a governmental body has violated any provision of this chapter, a court, A, shall assess each member of the governmental body who participated in its violation damages in the amount of not more than $500 and not less than $100. However, if a member of a government body knowingly participated in such a violation, damages shall be an amount of not more than $2,500 and not less than $1,000. A member of a government body found to have violated this chapter shall not be assessed such damages if that member proves that the member did any of the following. 1, voted against the closed session. 2, had good reason to believe and in good faith believe facts, which, if true, would have indicated compliance with all the requirements of this chapter. Writing, we have received. The court shall void any action taken in violation of this chapter if the court finds under the facts of the particular case that the public interest in the enforcement of the policy of this chapter outweighs the public interest in sustaining the validity of the action taken in closed session. Para E, court may issue a mandatory injunction punishable by civil contempt, ordering the members of the offending government body to refrain for 1 year from any future violations of this chapter. And finally, Iowa Code 21.6, para 4 states, quote, ignorance of the legal requirements of this chapter shall be no defense in an enforcement proceeding brought against this section, unquote. Supervisor Jorgensen and or Kiefer, do you wish to move to go into closed session at this time?
I can say,
I just finished this one sentence. Or would you rather discuss the potential liability to Floyd County alleged in Attorney Samantha Norris's letter to the board of supervisors and the county attorney in open session. Chair recommends the attorney. Would you like to comment?
Yeah, no, I appreciate that, and I just kind of to follow up to Dennis, to your question, the immediacy of this. Go to what I would say the last paragraph of Ms. Norris's letter. It basically says, if the board continues down this path, the current amended ordinance is passed at the October 9th, 2024 meeting, Marble Ridge may. They're, you know, if and may to me is imminent. If it was something that says, since the board has passed this, Marble Ridge will, then that's imminent, you know. That's where I draw my conclusion on the imminency of this. If it may, indicating that they may very well. It's not indicating that it's imminent, that it's gonna happen.
Thanks.
Yeah, clarifying why I'm saying what I'm saying.
So let's do this accordingly. Wait, if we want to do it, we would have to wait for imminent.
It has, I mean, right, I mean, the code says, it's clear, pending or imminent litigation, not potential.
If it's something we want to discuss in closed session, would it be prudent to table this until that imminency?
Table item 6,
Yeah.
that, I mean, necessarily, I mean, I think you want to discuss, you want to have the ability to discuss your liabilities, right?
Mm-hmm.
I, as a county attorney with potential adversary, watching, listening, and making record of our proceedings, you want to be somewhat careful, you know, you don't make liabilities and things like that. But we're a public board, right? Or you're a public board. We're a public entity. These laws of transparency, we have to live by.
Okay, now look at this. Well, how would we benefit from that?
Well, I mean, you can hear my thoughts in open session. I was asked on potential liability. And just because we discussed it, I don't think we necessarily put the county at a disadvantage by having a discussion. Right? I mean, these are common discussions about the impact of ordinances that you pass, right? And this doesn't, you don't have to wait till a lawsuit to have these discussions. In fact, it'd be nice to avoid not have liability for the county.
We could discuss and not take action.
Does the item call for action or is it just a discussion?
Review action.
That's for the going in.
That's for, excuse me, that's for going into closed session.
Oh, okay.
This is what we're talking
Okay. Understand. Thank you.
6D does not call for action. Discussion.
Okay.
So the question for the board at this time is whether or not there will be a motion to go into closed session. If not, if we don't approve going into closed session, we'll be discussing potential liability with the county attorney Pritchard in open session as a matter of public record. Is there a motion to go into closed session? Or or we would like to discuss this in open session? One more question?
Well, do we have to do, if we don't go into closed session, do we have to do item D?
Yes. The item before us is review action whether to go into closed session, and if we don't approve that, then we're gonna talk about it here in this room in front of everyone that's here. That is the recommendation.
It can't be tabled to a later date. It's an open discussion.
I think County Attorney Pritchard has already answered that question.
Did you,
You could table it, I don't see why we wouldn't have a discussion. I don't see that we're creating a problem by discussing the impact of ordinance. But, you know, it could be tabled, you guys, if you want, it's your agenda.
I'm clear on that now. I don't
If there is a motion to go into closed session, we are at item D. We're going to discuss the potential liability of the county attorney Pritchard. Anyone else who would like to comment in open session? Are you ready?
Yep.
Okay. We're moving to item D, 6D. If the board does not approve to go into closed session, discuss potential liability of the county attorney in open session. County Attorney Pritchard, I know you have spent considerable time researching the alleged issues raised by Attorney Samantha Norris concerning Floyd County's process and the current state of the proposed wind ordinance. I have a few questions for you. One, Mrs. Norris raises a number of potential issues that may be a liability in her letter. Two issues that greatly concern me are negotiating in bad faith and arbitrary regulation. Please explain what bad faith negotiating means, and how the Code of Iowa and the courts have treated governmental bodies who acted in bad faith.
I did, a few hours of research, not what I call it real extensive, but I've had this letter for a few weeks now. Some issues are raised that I just looked into. Say before I go too further, we have the author of the letter here. I think she is willing to speak, so certainly give her that opportunity. What I read from my research and looking into Iowa code and Iowa law is when boards such as board supervisors or planning and zoning, when they act with a purpose to regulate something out, basically to prevent an activity by zoning it and making it illegal to basically do the activity, right? When it's otherwise legal. That can be viewed as bad faith. And then a court can strike that down. They can say, hey, this goes too far, this regulation goes too far because you're over-regulating, you're zoning out a particular activity. And that's referred to in the letter. And it's, in the case law, it's a case that came out of the city of Des Moines with a cell tower, where they put regulations that just made it impossible to erect this cell tower in a place that was otherwise permissible for a cell tower. And so they said what the committee was doing was acting in a way that was making it impossible to do an activity. The court struck that down. There can be consequences for that in terms of costs. They can assess the costs and certain fees. So, when they look at that, they look at are you creating a regulation to make something that would otherwise be legal impossible, right? We call that zoning out. And I think, from our ordinance, we need to be careful as to what we pass or put in that ordinance if we're doing that, right? The other thing is just the arbitrariness. You've heard me speak about this.
I plan on asking questions about that in a moment.
I thought you want me to address that now. Or should
I've got a series of questions that I'd like to get. But that's one that's coming up. Thank you. I wrote this resolution 4223 that was approved unanimously by the board at our meeting on November 6, 2023. The resolution expressed the board's intent to, quote, facilitate the construction, installation, and operation of Floyd County's renewable energy resources in a manner that ensures the protection of the health, safety, and welfare of the residents of Floyd County and avoids any adverse impacts to the residents of Floyd County and Floyd County's agricultural producers, unquote. In light of recent amendments approved by a 2-to-1 vote of the board, do you believe a plaintiff such as Invenergy could argue, quote, bad faith negotiating took place? And would that argument be supported by passage of this resolution?
Well, I think the letter, I mean, in the letter, Ms. Norris points to things that she would identify as bad faith. I think things that could be labeled as like poison pill would likely be argued as just showing bad faith that made it impossible for this type of development. So I think that's something that the board ought to consider and take seriously. I mean, that gets to your zoning out the ability to do certain activity that's otherwise reasonable and legal.
Thank you. Mr. Norris states several amendments passed by, in her letter, she states that several amendments passed by Supervisor Jorgensen and Kiefer, quote, are arbitrary and capricious with no relation to legitimate government interest, unquote. How have Iowa courts dealt with the ordinances that are arbitrary and serve no purpose in terms of public safety or protection?
Short answer, I think, strike them down. Or they can remand to the board to reconsider. The court can kind of cut, say this isn't enforceable, this is arbitrary. We need to reconsider these regulations.
In your opinion, does Floyd County's current draft wind ordinance cross the line as being arbitrary and capricious? If so, please cite some specific examples.
Well, I don't know if I'm willing to really, at this point, say, you know, it's draft. I would think that, I would say this. If there are specific regulations that make it impossible to develop wind that's otherwise illegal, and they don't serve a specific public safety purpose, or they can be viewed as something that, like a poison pill, the only reason that regulation is there is it just makes it impossible for development. Then yeah, I mean, there's a real possibility that a court could say these go too far, they're arbitrary, they're in bad faith, because then again, you're getting to that point, you know, where what the court's saying, what the letter refers to is, you know, you're zoning to zone out a use, right? So Ms. Norris quotes that phrase, and that's the phrase I found too, is if you zone out a use. I've been thinking about this over the last few days. There's a show, a documentary I watched about the 3 Mile Island incident, right, from the late 70s and 80s. It deals with like a nuclear power plant, right? I mean, if you're familiar with the incident in Pennsylvania. And you think like, okay, when we regulate, like say a nuclear power plant, right? The regulations on that are extreme, you know, in terms of where you place the power plant, how you handle the material, the training, everything that goes involved, that's involved in that, right? And so you have really strict regulations, like on a power plant for a nuclear facility. Why? Because if you mess it up, you know, a simple mistake can cause, you know, catastrophic damage. You know, they talk about like the radiation leak, you know, that happened at 3 Mile Island. If the worst would have happened, they could have made an entire area, a 50-mile region, uninhabitable for centuries, right? So you look at, okay, those types of regulations are necessary because of how the hazard, how dangerous and the potential for catastrophe with the hazard, right? And so your regulations have to be tailored to make safe the activity that we're regulating, right? They can't go beyond. You can't regulate, say, my point is, you can't regulate a wind farm like you can a nuclear energy plant, right? Because there's different levels of risk. There's different potentials of catastrophe, right? So it's got to be proportional. It's got to be proportional to what the activity is and the threat to public safety. And if we implement regulations that zone out an activity that's otherwise legal, then we run the risk of being sued. We run the risk of having the courts come in, dictate, what's feasible or what we can and can't do. Those are my concerns. I'd be very curious to hear from Ms. Norris. I think she wants to speak. I'm gonna listen
Two more
with,
questions I'd like to ask.
I would love to hear from her and what her thoughts are, but I guess, the bottom line and reviewing and kind of diving into the issues that she raises in her letter, I would say that the board should take this letter seriously, should take note of it and understand potential fallout for the county if we go too far in some places with our orders.
Another question, I only have a couple more, thank you. I've got 4 right now.
Sure.
Is there a possibility that Floyd County wind ordinance, if enacted as currently drafted, could result in an Iowa court assessing financial liability against Floyd County to a plaintiff if Floyd County has acted in bad faith?
Yeah, no, Iowa law, I point that out. Iowa law can assess the cost. The court finds that there is bad faith on the part of the board. They can assess financial liability to the board, to the county. What that would be, I don't know. It's hard to say at this point. At least the costs of the litigation can be put on the county.
Thank you. You stated in your written opinion discussed previously about it is both likely Floyd County would be sued if the ordinance passes in its current form unquote. What do you believe the outcome of such a lawsuit would be?
I'm not going to speculate. I don't know. I just think that there is potential for liability for the county. That's the strongest statement as I'm willing to say.
And finally, as Floyd County's legal counsel, what is your recommendation to the board to avoid such litigation?
I think my recommendation is to take into consideration Ms. Norris's warnings, take into consideration my views, please, in terms of what constitutes arbitrary regulation, what can constitute bad faith on the part of the board in terms of drafting ordinances and implementing the recommendation, and try to stay within what I consider that reasonable zone of what courts have said is reasonable regulation, something that's related to the health and public safety of the county residents. Make sure that nexus is there. And this isn't just with wind, this is with everything that we do. Right? This isn't something that's just specific to this ordinance and this particular issue. This is something that applies to any ordinance that we do, whether it's livestock at large or vicious dogs or the wind ordinance, right?
Thank you for your research and your answers to my questions. Supervisors Kiefer and Jorgensen, do you have any questions for County Attorney Pritchard?
I have a question, maybe not so much for Todd, but for Samantha.
We're asking question right now from County Attorney Pritchard. We'll actually seek the floor for Samantha Norris at a later date. Do you have any questions for County Attorney Pritchard at this time? All right. Chair recognizes Samantha Norris for comments regarding her letter and the discussion that we had.
Samantha Norris with the Brownwood Law Firm. I represent the Marble Ridge Wind Farm. I appreciate the opportunity to offer some brief comments. I don't have a lot prepared. I want to keep this brief. I do want to note that Isaac Lampa, who's the developer of the project, is on the Zoom call, and he's available to speak to any specific questions you may have, particularly about the company's position. Marble Ridge is in Floyd County because the 86 landowners who have signed leases want to host the project on their land. It's a project that has been designed consistent with industry best practices to offer maximum benefit with minimal impacts. There's no doubt that Iowa's and the region's energy needs continue to increase at a very rapid pace. That is one reason that it is state policy to encourage the development of renewable energy and specifically wind energy. Marble Ridge wants to be here in Floyd County and believes the county and its residents would benefit from the millions of dollars in increased revenue that wind farms bring, and hopes that the board will pass an ordinance that does not make further wind development impossible, but rather appropriately balances both landowner rights and responsible wind development. When discussions of the ordinance began years after Marble Ridge had already been working to site the project in the county, the company was initially encouraged by the board's resolution, as read earlier, and the zoning commission's approach to the ordinance, both of which were balanced, responsible, and thoughtful. However, the company is concerned, as you read in the letter, with the most recent proposals. And they're concerned that the proposals have abandoned that reasonable, balanced, and thoughtful approach in favor of making it impossible to locate additional wind energy in Floyd County. Marble Ridge wanted to clearly share those concerns with the county in writing, in the hopes that the county would return to the approach and principles set forth in the board's resolution and as embodied in the ordinance approved by the zoning commission. Some of the specific areas of concern were outlined in the letter, but I'll repeat them here. Restrictive setbacks, which would make it nearly, if not completely impossible to site any further wind in Floyd County. A limit on the number of total turbines in the county. We believe that as you interpret that, it means maybe another 20 turbines maximum could be built in the county, which does not seem to be connected to a legitimate government purpose. The revisions to the definition of occupied structures seems well beyond the bounds of what is typically done in counties, whether you're regulating a wind farm or another type of development. The height restriction of 450 feet. Currently, the industry standard is roughly 500 to 600 feet, so this prohibits the use of newer technology. Those newer turbines are more efficient, and they are safer, and they are better. This height restriction would limit the use of those. And the sound limit of 40 dBA is also unnecessarily restrictive and well beyond industry best practices and the norms. So those are just a few of the examples from the recent amendments that we think are problematic. All of that being said, Marble Ridge is optimistic, that's why I'm here today, that a return to the ordinance recommended and passed unanimously by the zoning commission is still possible, and we welcome the opportunity to have an open dialogue with the county and this board if it's desired. The wind project, the Marble Ridge Wind Project, will benefit the county and its residents as well as the project's 86 landowners. But if the current revisions to the ordinance are approved, those benefits will all be lost, as will the millions of dollars that Marble Ridge has already invested in the project and in this county. The company respectfully requests that the board withdraw the currently proposed amendments and return to the ordinance approved by the zoning commission. I can stay up here if you have questions.
There's a comment referring to me as Supervisor Kiefer said in the September 3rd, 2024 meeting that no compromise could be made on the ordinance indicating a clear intent to stop any wind development within Floyd County. That's not true. The only comment that I made about no compromise was on removing the Board of Adjustment and replacing with the Board of Supervisors in New York and making a zoning.
Where you would have the ultimate say.
Shortly after that, I offered to compromise on the CSR. So that statement isn't true.
I apologize for that error. I think that is how we had taken down the notes for that day, but I do want to apologize. That was not our intent to misrepresent what you said.
Thank you.
Chair recognizes County Attorney Pritchard. Thank you. You had a list of items that you thought were, I think, categorized as overly restrictive. Is that fair?
Yes.
Can you kind of make sure my notes are
Yeah.
clear, like on what specifics you take issue with?
Yep. So in the letter and largely what I went through today, we listed in the letter and we listed them as an including but not limited to.
Okay.
And those items include the expanded definition of occupied building to include unoccupied structures, the height limit of turbines, the cap on the number of turbines, the restrictive setbacks, and the sound limits that were also put into place. And let me just make sure I don't have any. Nope, that's the list from the letter and that I read here.
Yes, Chair recognizes Supervisor Kiefer.
Who determines what's reasonable?
So that's a good question. Typically, what is done, we often refer to industry standard. A lot of times setback is 1.1 times the height, from an occupied structure, for example. So we do those things because if the worst were to happen, there would be adequate distance between, say, a road, a right of way, an occupied residence, or an occupied building. And so measuring it that way is typically what we determine is reasonable, and that is by and large what many counties do and what is industry standard, both in Iowa and elsewhere.
Reasonable can vary by county.
Certainly, you all have earned the right to put an ordinance in place that you think is reasonable and connected to protecting the safety and the health of your residents. But again, I would refer back to your resolution where you also want to balance that with the ability to site wind energy. And the reason that the typical setbacks are the typical setbacks is that because it balances the ability to site wind, and also you can scale it then to the size of the turbine. So if you have a turbine that's 50 feet higher than another one, the setback would then correspond as well. And so that is why those industry standards tend to be the industry standards, because they do adequately protect anyone from any potential harm, but it also allows for the wind turbines to be built. Right now, the setbacks would prevent that from happening.
Mentioned the 650s are safer. I don't understand how when you think about blade throw, ice throw, it's just going to go further. How does that make it safer?
I mean, the technology generally itself is safer. For ice throw, things like that. Again, if they're whatever can happen. The reason that the setbacks are often say 1.1 times the turbine height is it recognizes that those taller turbines would then need a little bit larger setback. But it's not just an arbitrary, number of feet, number of yards, number of miles. It is keyed to that turbine height, and 1.1 times the height is typically what we see.
Any further comments, questions from the board?
Don't have any at this time, no.
Supervisor Kiefer, thank you for clarifying the comment that was made about you in Samantha Norris's letter. In light of our discussion today, are you willing to compromise on any of the amendments that you previously supported that were so-called poison bills?
Already compromised on one, and that's the CSR.
So are you willing to talk about it on any others?
I haven't decided yet.
Supervisor Jorgensen, given our discussion today, are you willing to withdraw any of the so-called poison pill setback distances and other amendments, including turbine height, that you previously supported that effectively eliminate the possibility of future wind turbine development in Floyd County?
Yeah, I don't think I'm decided on that either yet. We've heard a lot now, so we need to, at least for me, I need to take that in.
Comment from please mute your phones to listen into our comments at this time. We'll give you an opportunity to comment a little bit later. I, for one, am encouraged by the last sentence of Ms. Norris's letter and her comments here today that states, to the extent that additional dialogue between the board and Marble Ridge would be beneficial, we would welcome that opportunity. Thank you for being here.
Thank you. I appreciate the opportunity. The company appreciates the opportunity.
And please be assured, I will be in conversation with representatives of Marble Ridge and other wind companies to draft and advance amendments that achieve the intent of Resolution 42-23. And I'll be submitting those amendments for your consideration at the third reading of the proposed ordinance on Wednesday evening. Is there any comment regarding our discussion from any member of the room or anyone who's listening on the phone? If you're listening, please identify yourself and make your comment. Thank you.
Chair.
Chair recognizes
Candy Brandall Larson. Can you hear me?
Zoning Commission.
I can barely hear you, but hopefully you can hear me. I would like you to read the entire resolution 4423 because the resolution that's posted on the county website is not match what you've been reading.
Okay. As I said, I wrote it. I remember where I was when I wrote it.
Let me pull it up from the website, Mark, and I'll compare.
All right. Resolution 42-23, amending the county ordinance pertaining to renewable energy projects. Whereas the Floyd County Board of Supervisors heard presentations on August 21st and August 28th from two wind turbine companies seeking voluntary easements from Floyd County landowners to develop utility scale wind projects in the county. And whereas the Floyd County Board of Supervisors were presented with a petition from residents in the county on October 9th, calling for the enactment of a moratorium on utility scale wind projects in the county and requesting an update of the county ordinance pertaining to utility scale wind projects. And whereas the Floyd County Board of Supervisors has taken into consideration the concerns and requests of the signers of the petition and the wind turbine companies by discussing options available to the board and how to proceed in the best interest of Floyd County, county residents, and Floyd County's agricultural producers at public meetings on October 9th, 16th, 23rd, and 30th. And whereas the Floyd County Board of Supervisors has requested the help of the North Iowa Area Council of Governments to assist the Planning and Zoning Commission and the board in amending the Floyd County ordinance pertaining to utilities scale wind projects and battery storage projects. And whereas the Floyd County Board of Supervisors has determined it is in the best interest of Floyd County and county residents to also update the county ordinance for solar projects and battery storage projects. And whereas the Floyd County Board of Supervisors believes the development of Floyd County's renewable energy resources has the potential to benefit the county and county residents for providing lease or easement payments to landowners, increasing needed property tax revenue to the county, increasing the use of the county's clean renewable energy resources, and by enhancing local economic development through job creation. And whereas the Floyd County Board of Supervisors desires to facilitate the construction, installation, and operation of Floyd County's renewable energy resources in a manner that ensures the protection of the health, safety, and welfare of the residents of Floyd County and avoids any adverse impacts to the residents of Floyd County and Floyd County's agricultural producers. And whereas the Floyd County Board of Supervisors seeks to balance needs, interests, and concerns of Floyd County, county residents, Floyd County's agricultural producers, and the renewable energy companies seeking to develop renewable energy projects in Floyd County. And whereas the Floyd County Board of Supervisors seeks to ensure a timely, expeditious, thorough, transparent, and open to the public review and amendment of the county ordinance pertaining to renewable energy projects, therefore be it resolved. The Floyd County Board of Supervisors hereby approve an agreement between the North Iowa Area Council of Governments and Floyd County pertaining to amending the Floyd County ordinance for utility scale wind development, battery storage, and related sections of the ordinance in accordance with Iowa Code Chapter 335 County Zoning. An agreement between NIACOG and Floyd County pertaining to amending the ordinance for utility scale solar development and related sections of the ordinance in accordance with Iowa Code Chapter 335 County Zoning. Be it further resolved, the Planning and Zoning Commission shall comply with Iowa Code Chapter 21, the Iowa Opens Meeting Law, during all meetings regarding amending the county ordinance pertaining to renewable energy projects, including listening posts, workshops, and public hearings to amend the county ordinance. And the chair of the Planning and Zoning Commission or the zoning administrator shall not impose any requirement that all members of the Planning and Zoning Commission and the Board of Adjustment be present to conduct business at any meeting of the Planning and Zoning Commission. And the chair of the Planning and Zoning Commission or the zoning administrator shall not attempt to establish private meetings with one or more members of the Planning and Zoning Commission and the Board of Adjustment with any developer of a renewable energy project in Floyd County or the developer's representative outside of a regularly scheduled meeting of the Planning and Zoning Commission. And be it further resolved, the Board of Supervisors recommend to the Planning and Zoning Commission that the amendment to the county ordinance pertaining to renewable energy projects shall include, but not be limited to, a review and consideration of the following. 1, establishing minimum setback distances from neighboring properties. 2, a clear and well-defined plan to support potential decommissioning. 4, a pre-construction plan for handling potential impacts to roads and other infrastructure. 5, a post-construction plan to identify impacts and provide for repair. 6, a basic set of minimal safety standards. 7, a written emergency plan covering all reasonable scenarios. Passed and approved the 6th day of November.
That is
Yes,
not,
that's not what's on the website.
All right, then. Would you move through that one? I know we did not include solar projects at this time. We did not go with NIACOG in approving the solar project.
Hopefully I'm not interrupting, but I can't hear anything. So if you're talking to me, I can't hear you.
You're not missing anything, Candy. We're just looking up the resolution that appears on the website. That's what Outer Car looking at. I'm looking up the resolution that was passed. and see if there's any difference, because we have our resolutions right there.
Did any of you get it in an email yet?
So
Did any of you get it in an email yet?
resolution,
You send what you know.
Yeah. Like me to read it or?
oh, well, I'm looking the wrong year. I'll get it when I look back to 2023, excuse me. All right, resolution. Yes, resolution 4223, amending zoning ordinance pertaining to renewable energy projects. Quiet, please. We do not allow, mute your phones, please. I want to correct what I read earlier. This resolution was in large part correct, although what was deleted in the resolution that we passed was in Floyd County pertaining to the amendment. That's what we did when we effectively approved it. Did include, be it further resolved, the Planning and Zoning Commission shall comply with Iowa Code Chapter 21. The Iowa Opens Meeting Law during all meetings regarding amending the ordinance pertaining to renewable energy projects, including all listening sessions, workshops, or public hearings. And the chair of the Planning and Zoning Commission or the zoning administrator shall not impose any requirement that all members of the Planning and Zoning Commission and the Board of Adjustment be present to schedule and or conduct meetings or business at any meeting of the Planning and Zoning Commission. We did not include in the resolution, be it further resolved, the Board of Supervisors recommend these 7 things. I don't know if that's the one that's posted on the website.
Right.
In its entirety. Yes, that answers your question, Danny.
Yes, thank you.
Any other questions, comments from anyone listening on the phone line? Hearing none. Any final comments from anyone? Members of the board? We'll see you all Wednesday night.
Pretty, I believe, isn't it?
Yes, it is. All right, thank you. Thank you for the thorough discussion. Item 7. Review and action regarding appointment to the Conservation Board. Packet, we had a note from Adam Sears that we have a applicant, I believe his name is Max Gisselson, who wishes to become a member of the Floyd County Conservation Board, and besides the reasons for, I know you probably reviewed that. Sounds like he would be a very good candidate for that position. He has an interest in a lot of the work that we're doing there.
You just want to applicant. What we're presented with.
That's correct.
You were to approve this one, this is to fill the remaining position that would end June 30th, 2025. This be for 7 months.
Reappointed at that time.
I'll make a motion to Max Gilson to the Conservation Board.
Second.
We have a motion by Supervisor Jorgensen, and a second by Kiefer to approve Max Gisselson as a member of our County Conservation Board. Further discussion? Those in favor of the motion say aye.
Aye.
Aye. Great, welcome on board to Max. Item 8. I received a letter from Delbert Longway. Those of you who might remember that name, he's the Chief Jail Inspector for the state of Iowa, and in his letter he writes regarding the Floyd County Jail inspection. Dear Chairman Keelan, the Floyd County Jail was inspected on September 27th, 2024 by the Iowa Department of Corrections as required by Iowa Code Section 356. To ensure compliance with Chapter 201-50 of the Iowa Administrative Code, the inspection included an examination of staff training records, required documentation, prisoner files, jail policy and procedures, and a tour of the jail. Floyd County is a clean, well-managed, and well-maintained facility. Documentation was complete. The manual is complete and well-written. It was a pleasure to work with the professional staff of Floyd County Jail. I wish to express my appreciation to Sheriff Jeffrey Crooks, Chief Deputy Pat Shirley, Jail Administrator Taylor Isaacson, and jail staff for assistance and cooperation during the inspection. Sincerely, Delbert Longway. Nice to get a complete bill of health and a very good review from our Chief Jail Inspector. Item 9, review action regarding approval of Finger and Toes liquor license application. Dr. Carr, would you read this applicant and their application for us? Thank you.
Yes, this one is Fingers and Toes is owned by Marianne Carolyn. She has a business east of Mouse Corner. She has an event that she does where you can go out and sample wines that she has, and every year she requests a liquor license in order to have that event. Everything's good with the application. So the property is owned correctly. We have a sketch on file from her previous, nothing's changed.
Any questions, comments regarding the application?
I'll make a motion to approve the application of Fingers and Toes liquor license.
I'll second.
Have a motion by Supervisor George Kiefer, seconded by George Jorgensen to approve the application of Fingers and Toes liquor license. Further discussion? Hearing none, those in favor of the motion say aye.
Aye.
Motion carried. Item 10, note the chair's approval of sip by sip liquor license application. This is a most unique situation, and I'm going to ask for Auditor Carr to also explain what took place, and it was our decision not to call a special meeting of the board to approve this application. There were some unique things about this that prompted that decision. I'm going to talk about when we received it and what we didn't get, time and matter.
So I received a call from Jennifer in an email that you have there. Jennifer Billmeyer, who has a Volvo truck, and on Wednesday afternoon, I received a call from her. I had not received any notice from the Alcoholic Beverage Division about this license, so I went online and looked. The application was out there. I did verify. I received no email from them. Actually, while I was out there, saw the one from Mary Ann Carolyn also, which I did not receive notice on, but that had a little bit more time. This is an event that was held this last weekend at Dustin and Emily Murray's residence, and so in order when they do the liquor license, they also have to have, they can't order their alcohol for the event until their liquor license is approved. So that was the timeliness of all of this for her to be able to get the license approved and get the alcohol ordered for the event. And so I asked Mark if he would be willing to do this. I do have the sketch on hand for where the alcohol, that in your packet, where the alcohol will be sold, consumed, stored, all of that. And I also have the agreement from Murray's that it's okay for her to come on site to their property for the event. So it's just a timeliness of this in order for her to get the alcohol ordered timely as well once it was approved. So I called Mark. I did get an email from her on October 2nd at 2:41 p.m. With the required information as well. And, with all documents in order, I asked Mark if we would consider approving it without holding a special meeting.
Thanks, Mr. Risk.
Yeah. Good.
All right, thank you for the explanation, Auditor Durham. Next item is item 11, future agenda items. Adjourn.
Second.
Have a motion by Supervisor Jorgensen, second by Keith, to adjourn. Those in favor say aye.
Aye.
Aye. We're adjourned. Thank you.